Excellencies, distinguished guests, ladies and gentlemen, it is a great privilege to address this inaugural ASEAN Integration Summit on the eve of truly exciting times in the modern history of Southeast Asia's economic integration. I congratulate the organizers for having brought together such an impressive summit and assembled a stellar list of speakers and attendees. Sadly, I am not able to be with you in person, but must address you via a pre-recorded presentation. This is because your summit coincides with the Hague Conference on Private International Law's annual meeting of the Council on General Affairs and Policy, the highest organ of the Hague Conference. Ladies and gentlemen, it is with great interest that the rest of the world, including us at the Hague Conference, has been watching ASEAN's steady progress towards Asian regional integration. That progress is about to take a critical step. The ASEAN Economic Community, AEC, is set to commence in December 2015. Mandated under the AEC blueprint, ASEAN is to move towards a single market and production base with the free flow of goods, services, investment capital, and skilled labor. Fundamental to the blueprint is system integration that eliminates tariff and non-tariff barriers, reforms rules of origin, facilitates trade, integrates customs, and promotes a single window policy. It also identifies a barrier to trade and investment that is frequently overlooked: the often significant differences between domestic laws and the multifaceted private international law issues that result from these differences. Thus, the blueprint calls for the harmonization of legal systems for the benefit of the economic actors, including in the area of capital market standards, e-commerce, including electronic contracting, and dispute resolution. ASEAN's law ministers consistently echoed this call to complement economic integration. And the call is warranted. A lack of harmonization creates significant uncertainty for those who trade and invest. The result can be stunted economic growth. Today, I want to zoom in on a particular subject identified by ASEAN's law ministers: dispute resolution, and specifically cross-border litigation. I submit that some of the Hague Conference's conventions and instruments, which actually already apply to some ASEAN members, provide ASEAN with off-the-shelf solutions that offer frameworks with a proven track record and which promote legal certainty and predictability and thus provide efficiency in relation to cross-border litigation within the AEC and indeed beyond. But why are such frameworks so important to regional integration? It is almost trite to state that the increased cross-border trade and investment among ASEAN's member states will inevitably result in a rise in related cross-border litigation. Traders and investors recognize legal disputes as a reality of their dealings, but consider it a risk that requires management and that has an economic effect. Of course, even though litigation risks exist in domestic settings, it is clear that risks associated with cross-border disputes are more complex, are more difficult to manage, have less certain and predictable outcomes. The result can be put in two ways. If the risk is too high, that is, managing it becomes economically prohibitive or even entirely impossible, traders and investors alike are more likely to refrain from engaging in cross-border commercial activity. If, however, the risk is more manageable, including by appropriate regulatory activity that creates a positive trading and investment environment that has a high degree of legal certainty, that features efficient procedures and that has a good predictability of outcome, trade and investment will be facilitated and encouraged. So, how can the Hague Conference, through its conventions and instruments, assist with creating a regulatory environment that is good for trade and investment? Before I proceed, I invite you to consult the printout of a PowerPoint presentation which has been included in your material. It gives you an overview of the Hague Conference, its work and its global reach, and its current connectedness with ASEAN states. And I would like in particular to go to part 2. If you have this handout, I would invite you to go to part 2, which shows to what extent existing ASEAN members are integrated into the Hague Conference on Private International Law. And you can see there on a series of maps that out of the 10 ASEAN members, only Vietnam, Singapore, the Philippines and Malaysia are actually members of the organization. Some of them are party to at least one of our conventions. And you can also see that Thailand, Cambodia and Brunei Darussalam, while not being a member of the organization, still are party to at least one of our conventions. I now ask you to consider 6 questions which regularly arise in the course of cross-border commercial relations and possible disputes. To what extent, that is my question 1, to what extent is the authenticity of a public document executed in Malaysia, say an extract of a commercial register, a notarial act or a civil status document, recognized in a Vietnamese court? Question 2. How does a plaintiff in the Philippines serve process or other court documents on a defendant in Brunei Darussalam? How does a Cambodian plaintiff compel a witness in Indonesia to appear before the courts to give evidence? How do the courts of law recognize a trust formed under the common law of Singapore? How does a lender in Thailand obtain a recognized security interest for a loan to a person in Myanmar? Is there a regime that allocates jurisdiction among courts where a claim has connections with more than one member state? Ladies and gentlemen, the Hague Conference is the world's leading institution for the development and implementation of multilateral agreements designed to provide litigants with the legal certainty and predictability of outcome they require in a cross-border context. And Hague Conventions and instruments can provide the answers to the questions I just posed. With its conventions and instruments, the Hague Conference can offer ASEAN member states the legal toolkit that creates a positive trading and investment environment within AEC. The organization offers pre-packaged, comprehensive legal frameworks developed by legal experts from around the world. The frameworks work equally well with Eastern, Western, common civil, post-communist or Sharia law systems. They are free from foreign bias and they serve as international, indeed global, best practice benchmarks in cross-border legal cooperation and private legal disputes. The Hague Conventions may in fact be compared to bridges, connecting legal systems, but at each end of the bridge, the substantive law of a legal system remains untouched. They offer the prospect of regional integration of the AEC, while at the same time ensuring that a region can also integrate globally. I pause here to note that the AEC Blueprint Part 2D stipulates this aspect as one of the primary goals of ASEAN. Importantly, both regional and global integration happen at the same time, In particular, there is no need for complex, time-intensive and thus costly negotiations of individual bilateral instruments. By becoming a party to these Hague Conventions, you immediately become party to a worldwide regime that also applies at the regional. And the Hague instruments allow for sufficient flexibility to go beyond their regulatory reach. For example, should ASEAN in the future decide to change to a regime in which public documents can circulate freely within the AEC without having to authenticate their origin, it can do so, even with the Hague Apostille Convention in place. The convention would then still take care of the AEC's global integration, but among AEC, the free circulation of public documents would be guaranteed. Therefore, I suggest that ASEAN member states should consider acceding to our conventions and instruments to avail themselves of coherent, credible, and workable frameworks for the use of litigants in the AEC. But let me now turn to the 6 questions. I am keenly aware that I owe you a few answers. I pose the questions to correspond to 6 Hague Conventions and instruments, including the 1961 Apostille Convention, abolishing the requirement of legalization and essentially replacing it with one single formality. The 1961 Apostille Convention, abolishing the requirement of legalization and replacing it with one single formality. The 1965 Service Convention, the 1970 Evidence Convention, the 1985 Trusts Convention, the 2006 Securities Convention, and the 2005 Choice of Court Convention. My answers highlight how they create an environment that is positive for trade and investment. In particular, question 1. Remember the circulation of public documents. The 1961 Apostille Convention could provide litigants within the AEC with a uniform framework that reduces the requirements for legalizing and notarizing foreign public documents. It is actually interesting to note that the World Bank Group, the International Finance Corporation of the World Bank, assesses how attractive a jurisdiction is for foreign direct investment also by taking into account whether or not that jurisdiction is a party to the Apostille Convention. A state party to the Apostille Convention gets one more point in the overall assessment ranking and thus is considered to be more attractive a jurisdiction for foreign direct investment. Here you have a very direct, immediate link between a very important Hague Convention that is in force in more than 100 states around the world and cross-border commerce and foreign direct investment. The 1965 Service Convention establishes a uniform framework that streamlines the process required to serve validly legal documents on a party located abroad. This convention is in force in more than 60 states around the world. The 1970 Evidence Convention provides mechanisms that allow to validly taking evidence from a witness from a party located abroad, an instrument that is in force in more than 50 contracting states. The 1985 Trust Convention could provide a method by which a trust, a common law concept, could have its validity and legal attributes recognized in a civil law or Sharia law country abroad. The 2006 Securities Convention allows the easy determination of requirements that exist to perfect a security interest, say a pledge, over intermediated securities so as to make it enforceable, including against the party located abroad. These are very often rather important sums that are at stake here, and therefore it is again very important to know which law applies in a cross-border setting to the perfectional requirements of a security interest. The 2005 Choice of Court Convention provides parties to a contract featuring a choice of court clause with legal certainty that the clause is effective, that if they have chosen the courts in Singapore as the courts to hear their litigation, that indeed the courts in Singapore will end up hearing the case, and that the parties, despite their choice, do not suddenly end up in the courts in a foreign jurisdiction. As is apparent immediately, the Hague Conference conventions and instruments A. provide practical solutions that speed up and make more effective the resolution of disputes, and B. improve certainty and reduce litigation costs. These instruments promote legal certainty and predictability of outcome. They create, I posit, an environment that is highly positive for cross-border trade and investment. I strongly believe that joining them would be of significant benefit to all ASEAN member states and the AEC. Ladies and gentlemen, the Hague Conventions and instruments provide solutions to many issues parties encounter in cross-border litigation. They are live instruments. Their proven record of accomplishment demonstrates their success across the globe. Joining these conventions and instruments will remove several significant obstacles to the ASEAN's regional and global economic integration with the stroke of the pen. They are a pathway from economic idealism to legal realism. I commend the conventions and instruments of the Hague Conference on Private International Law to ASEAN. My organization stands ready to support ASEAN and its member states on its ambitious journey towards the AEC, including through targeted and tailored technical advice and assistance. Thank you very much for your attendance. Sorry, I have to do the last one. Thank you very much indeed for your interest in the work of the Hague Conference. I wish you all a very fruitful summit with interesting discussions, and I very much look forward to our continuing cooperation between ASEAN and the Hague Conference on Private International